If you want a good laugh, then you need to watch this. Hello, my fam. It is Perez, the queen of all media, the original influencer, and your number one source for everything It Ends With Us saga. In the words of Ryan Reynolds, you can't sue for hurt feelings. But that's exactly what his wifey is trying to do. Boone Hall Bridezilla is the one calling all the shots here. Her lawyers are making millions upon millions off of her, thanks to Ryan Reynolds' bank account. They're just going along for the ride. Grifters be grifting. Lawyers be lawyering. Now, I know a lot about defamation. And even if you don't, we've learned a lot in this case together. Because Lil Bump Lively is a former B-list, now turned F-list actress, she is a public figure. The bar to prove defamation against her is very high. But her lawyers are claiming that Baldoni's lead attorney, Brian Friedman, has defamed her for stating that she's a liar. That's not defamation. As we also saw when Ryan Reynolds and her publicist, Leslie Sloan, were dismissed from this case, Baldoni's attorney was just repeating what he believed to be true per his clients. Just like Blake Lively's husband and publicist were saying what they were saying because they believed her. Brian Friedman calling her a liar when he believes she's a liar is not defamation. Oh, and good luck trying to prove malice. But Baldoni's attorney is not being sued here. He is. So literally moments ago, lawyers for the accused racist filed a motion for sanctions against Brian Friedman. And this is a doozy. Her lawyers tell the judge, quote, plaintiff Blake Lively respectfully moves to impose sanctions on defendant's counsel Brian Friedman for repeatedly violating Rule 3.6 of the New York Rules of Professional Conduct, which this court adopted as an order applicable to all counsel of record and susceptible to punishment pursuant to Rule 16F of the Federal Rules of Civil Procedure or the court's inherent power. For background, the New York Rule of Professional Conduct 3.6 governs trial publicity, specifically addressing a lawyer's extrajudicial statements that could prejudice legal proceedings. It generally prohibits statements a lawyer knows or reasonably should know will be disseminated publicly and have a substantial likelihood of materially prejudicing an adjudicative proceeding. However, certain types of statements are permitted, and lawyers can also respond to statements made by others that might require a response to avoid prejudice. What are some of these exceptions that a lawyer can share with the press? Well, they can share basic information about the case or the offense or the defense. They can talk about public records. They can talk about the investigation. They can talk about litigation steps. They can talk about assistance requests. They can talk about a lot. And honestly, even somebody who just graduated high school, I would expect a lawyer to say the opposing party is lying. These claims are made up. That's like a given, right? Their request for sanctions continues, saying, quote, almost immediately following the court's order, Mr. Friedman began violating it and has continued to expose the public and the jury pool to his biased and inflammatory pre-trial indictments of Miss Lively's character, credibility, and reputation. The lack of support for his statements appears irrelevant to Mr. Friedman because, as he personally explained to this court on February 3rd, 2025, quote, "In these kinds of cases, once someone says something, it becomes fact." Mr. Friedman's pattern of prohibited attorney statements warrants the imposition of sanctions. Despite his enthusiastic endorsement of the application of New York Rule 3.6 to this case during the February 3rd hearing, Mr. Friedman resumed publicly slandering Miss Lively's character and credibility within a matter of days, including in friendly interviews conducted by his former clients. On February 5th, Mr. Friedman appeared on TMZ to discuss the court's order and whether Miss Lively and her husband, Ryan Reynolds, would try to avoid a deposition, and stated that he hoped he would not get sanctioned as a result of the interview, but that he was sure you guys will indemnify me, so we'll be good. In the following weeks, Mr. Friedman has repeatedly made, you guys, it's been months since February. Big mistake there. Grammatically, In the following weeks after that interview, I'm guessing is what they meant to say. In the following weeks, Mr. Friedman has repeatedly made public statements attacking Miss Lively's character, credibility, and reputation. New York Rule 3.6 stating, for example, that she is afraid of the truth, has been testifying since the moment she auditioned for this part, is obviously uncomfortable with the truth, and is a privileged elite who has been abusing our legal system to cover up for the self-concocted disaster she initiated. What's wrong with any of that? Nothing, I think, but I'm not a lawyer. During one interview conducted by his former client, Megyn Kelly, Mr. Friedman made numerous disparaging comments about Miss Lively, while Miss Kelly referred to Miss Lively as a bitch. Through his comments, Mr. Friedman has sought to advance 4 themes designed to attack Miss Lively's credibility, character, and reputation. Miss Lively is a liar who is afraid of the truth and cannot be believed. She is a person of bad character, namely a privileged elite and bully who is manipulating the judicial system, in contrast to Mr. Baldoni, who Mr. Friedman proclaims is a person of good character who should be credited and supported. She manufactured her SH and retaliation claims because, in Mr. Friedman's view, she could not accept the public's organic response, disapproving of her, ignoring, of course, that Miss Lively's retaliation claims are based on his own client's written words in dozens of texts and emails. What? They include a little footnote there that says, as laid out below, Mr. Friedman's strategy appears designed to harden public opinion in advance of the actual evidence being introduced at trial. For example, Mr. Friedman's repeated representations about the organic backlash to Miss Lively is not only directly contradicted by numerous allegations in Miss Lively's amended complaint, but a recently produced, and then this next part is redacted. Ooh. They filed this motion for sanctions under seal, meaning the redacted parts the public won't get to see. Back to that request for sanctions. And 4, that she cannot be believed because her husband, Mr. Reynolds, made an appearance on Saturday Night Live during the course of the litigation. All of this is improper and sanctionable. New York Rule 3.6 forbids Mr. Friedman's unrelenting campaign attacking the character, credibility, and reputation of both Miss Lively and Mr. Reynolds. Now is the appropriate moment for this court to ensure compliance with New York Rule 3.6. The parties have just completed the first deposition in this case, and Mr. Friedman wasted no time in attempting a public relations stunt, namely by filing the entire pre-reviewed and pre-corrected transcript on this court's docket in a transparent ploy to make the deposition a public event. These tactics raise serious concerns given Mr. Friedman's conduct to date of efforts to improperly influence the jury pool by making misleading public statements about testimony, evidence, and the state of discovery. Sanctions are necessary and appropriate to address Mr. Friedman's infractions and to prohibit further efforts to engage in a public relations strategy designed to malign Miss Lively's character and credibility. For the reasons described herein, the court should hold that Mr. Friedman violated New York Rule 3.6 and the order and impose sanctions under Rule 16F, including by admonishing him against making any future statements attacking the character, credibility, or reputation of Miss Lively, Mr. Reynolds, and any other party or witness in this matter. They then proceeded to highlight all of the very problematic things that Brian Friedman has said publicly. After that February 3rd hearing and the judge imposing New York Rule 3.6, he gave that interview to TMZ, which we just discussed. Then on February 18th, Mr. Friedman gave a 30-minute interview on the podcast hosted by his former client, Billy Bush, in which, in reference to the parties in this case, he said that documents don't lie, people do, and further cautioned anyone who might be inclined to credit Miss Lively's allegations that I wouldn't want to be on the wrong side of history here. That's problematic. That's sanctionable. On February 19th, Mr. Friedman responded to the filing of Miss Lively's amended complaint in a press statement to TMZ, in which he asserted that Miss Lively's claims are false, filled with unsubstantial hearsay of unnamed persons who are clearly no longer willing to come forward or publicly support her, and lacking actual evidence, as documents do not lie and people do. That's problematic. On March 19th, Mr. Friedman gave a press statement to People magazine where he described Mr. Reynolds' motion to dismiss, which was subsequently granted in full, as arrogant. This is the most ridiculous thing. Not just a waste of her lawyer's time, but a waste of the court's time. This is ridiculous. Boo-hoo, he called Ryan Reynolds arrogant. And Mr. Reynolds as someone who believes that bullying is acceptable, alongside his false insistence that Mr. Reynolds was publicly documented to be a key player whose fingerprints have been all over this smear campaign against Justin and the Wayfarer team since day one. I mean, they did bring the receipts-proof timeline of all the times that Ryan Reynolds was involved in everything, and he was quite involved at meetings, advocating on her behalf. According to Baldoni, getting him dropped by his own agency. On March 20th, Mr. Friedman gave a press statement to TMZ wherein he accused Ms. Lively's motion to dismiss, which was subsequently granted in full, of attempting to cover up for the self-concocted disaster she initiated, and further smeared Ms. Lively as being a privileged elite whose motion to dismiss twisted and curated the law to fit her personal agenda in one of the most abhorrent examples of abusing our legal system. On April the 4th, Mr. Friedman gave a press statement to TMZ in which he accused Ms. Lively of attempting to divert the public's attention from the receipts, the actual documents, video footage, and additional evidence, which Mr. Friedman asserted made it irrefutable that there was no SH. That Ms. Lively's own conduct, rather than the retaliation campaign she alleged, was responsible for the organic backlash that she received, and that Ms. Lively does not need discovery to find out who smeared her. Just a mirror will do. That was good. Also on April 4th, Mr. Friedman gave a press statement to People magazine in which Mr. Friedman characterized Ms. Lively as belonging to a circle of Hollywood elites seeking to advance false and harmful claims and block access to the court system and weaken our nation's constitution to service those who are in position of power. On May 8th, Mr. Friedman gave a press statement to People magazine wherein Mr. Friedman proposed holding Ms. Lively's deposition at Madison Square Garden and to sell tickets or stream it. That was funny. Sanctionable? On June 10th, in a 5-minute interview with TMZ, Mr. Friedman proclaimed Ms. Lively is afraid of the truth, said we're going to see if she's going to appear at the deposition or not, and contrasted Ms. Lively's character with that of his clients, accusing her of filing a lawsuit which accused some very good people of a smear campaign, and accused, a terrific young man of SH. On June 11th, in a 50-minute interview on a podcast hosted by his former client, Megyn Kelly, Ms. Kelly opened the podcast by conveying that Mr. Friedman is waging war against Ms. Lively, who he believes is not a good person, and later referred to Ms. Lively as having the reputation for being a bitch. An assertion which Mr. Friedman endorsed in a lengthy discussion of Ms. Lively's character, noting that Ms. Lively appeared to him to be a narcissist who could not accept, in his view, how she's behaved and how she's treated reporters and how she's treated people and how she's treated individuals, how she's treated waiting staff and others, and saying it's not okay. We don't like you. Wow. Can you believe Justin Baldoni's attorney said all of that? That is sanctionable in her mind, and only in her mind. I have no faith in this judge, but 99% sure that this request for sanctions will be denied because this is peak ridicula. They then waste too many paragraphs talking about New York Rule 3.6 specifically, as well as Federal Rule 16F. That one says that the court may issue any just order if a party or its attorney fails to obey a scheduling or other pretrial order. The order in question here is that you be on your best behavior and don't taint the jury pool, with comments that have not tainted the jury pool. Especially because most people have not been making content about the lawyers. The majority of the content have been about her filings and things that we've learned, right? Listen, every once in a while, I'll make a video about a statement, or this lawyer said that, or this lawyer said that in an interview. Remember, her lawyers have also given interviews. But the majority of my content is not that. And the majority of the other content out there is not that either. And then they talk about the court's inherent power to issue sanctions. They argue that Mr. Friedman has violated New York Rule 3.6 and this court's order. They're basically rehashing everything that they said earlier. Specifically, he should be sanctioned for calling her a liar who is afraid of the truth. That he should be sanctioned for attacking her as a person of poor character in contrast with the good character of his clients. Bully privileged elite. That he should be sanctioned for violating New York Rule 3.6 by claiming that the source of the retaliation campaign Miss Lively has challenged is an organic response. It is. In this section, though, there is a big chunk that is redacted, which I'm very curious about. It comes right after this part that says, the evidence already contained in Miss Lively's amended complaint demonstrates the patent falsity of Mr. Friedman's insistence that Miss Lively's reputation prior to the release of the film was responsible for the almost instantaneous and vitriolic backlash to Miss Lively's immediately after the film's release. For example, Miss Lively recently received, only after litigating a motion to compel its production, and then redacted. And this is just one email among a mountain of other evidence. As the court acknowledged in prior rulings, it is readily apparent, based on communications between the Wayfarer parties included in the pleadings, that they engaged in a retaliatory smear campaign. The court has not said that, babe. Wrong. That's not apparent. No. Nice attempt at rewriting history and shifting the narrative. But I see right through you. Mr. Friedman's attempt to blame Miss Lively's allegedly poor reputation undermines the real grounds on which this case must be decided. Evidence presented to an impartial jury. Also, Mr. Friedman violated New York Rule 3.6 by asserting that Mr. Reynolds' SNL appearance makes him a person of poor character and renders Miss Lively's claims not credible. I can't believe I'm reading all of this. This is just so crazy. This is why I love the It Ends With Us saga, because it defies all logic. This motion for sanctions is peak Delulu from Team Delulu. Mr. Friedman's public statements regarding Mr. Reynolds' appearance on SNL have been part of his lengthy campaign to tar Miss Lively as a liar and likewise violate New York Rule 3.6 and this court's order. The court should sanction Mr. Friedman for violating Rule 3.6 and the court's order. Sanctions are appropriate. And this was all just for show. As admitted by her own lawyers, they write to the judge, quote, although Miss Lively seeks only a public admonishment and an award of costs and fees at this time, Miss Lively reserves all rights to seek appropriate remedial instructions prior to trial, as well as to seek additional sanctions in the event Mr. Friedman continues to violate the New York Rule 3.6 order, including but not limited to revocation of Mr. Friedman's pro hac vice admission, meaning he would not be allowed to represent Justin Baldoni in New York in this trial. Indeed, there is serious reason for concern as depositions and document discovery continue that Mr. Friedman will spend the next 8 months seeking to undermine or manipulate the material exchanged in discovery to litigate this case in the court of public opinion, prejudicing any future jury before the parties are able to make their respective cases in court. Mr. Friedman's plea to the people that'll be the jurors that hopefully they'll be able to see the sky is blue, contrary to Miss Lively's supposed interpretation, demonstrates his intention and willingness to do just that. Miss Lively respectfully urges the court to police these boundaries before irreparable damage is done. And groundworks for their mistrial, right? Wrong! Additionally, the judge just could use the court's inherent power to reprimand Mr. Friedman. They tell the judge that Mr. Friedman happily agreed to be bound by New York Rule 3.6 and expressed no confusion as to what compliance entailed. However, just 2 days after the order was entered to be bound by this New York rule, Mr. Friedman began to violate it and even joked about the prospect of being sanctioned by this court in a public interview. Since that time, Mr. Friedman has unrelentingly engaged in pretrial publicity akin to, and at times worse than, those instances raised at the February 3rd hearing. Mr. Friedman's routine and continuous violations of the order indicate he acted willfully and in bad faith. The court should impose additional sanctions under its inherent power. Mr. Friedman's willful violations of the New York Rule 3.6 order separately justify the imposition of sanctions, including a public reprimand and attorney's fees, as well as any other sanctions the court deems just under the court's inherent power. Conclusion. For the reasons stated above, Your Honor, your most esteemed, your most venerable, is that a word? Venerable? Your sexiest, smartest Judge Lyman, this court should impose sanctions against Mr. Friedman in the form of findings that he has violated the New York Rule 3.6 order and an admonishment against future violations, in addition to an award of costs and attorney's fees. Should the court conclude that an award of fees and costs is appropriate, Ms. Lively respectfully requests that the court set a briefing schedule for the calculation of that award. Respectfully submitted, Mikey Mike Gottlieb. Additional conclusion by me. Ka 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 ka. I don't want this to end. I'm so glad we've got 8 more months. Yay! This is honestly, like, I cannot recall a better soap opera, real or fiction. This takes the cake. All right, my fam, I already told you, I think the judge is not going to impose any sanctions. The judge is not going to admonish Mr. Friedman because Brian Friedman has not said anything mentioned here that is admonishable, I believe. And I have little faith in Judge Lyman, but anything is possible. What do you think of this motion for sanctions? Do you think it will be granted? Do you think it's sincere? Or do you think, like me, it's just pomp and circumstance? Let's discuss everything in the comments section.